committed, and far from taking any reasonable steps to prevent genocide, it deliberately endorsed and perpetrated it. Myanmar also had relevant knowledge of the commission of genocidal acts by ethnic Rakhine civilians, and yet, far from taking steps to prevent them, Myanmar incited them to join its genocidal campaign. There has been a flagrant breach of the duty to prevent. Alongside and subsequent to that violation, Myanmar has also violated the duty to punish genocide, as contained in Article 1, and supplemented clear duties to respond in the face of genocidal acts by way of prevention and punishment, and to create domestic frameworks that inhibit and deter the commission of genocide. The duty to punish arises notwithstanding that Myanmar was itself the perpetrator of genocide. It nevertheless had for the breach by the state of its obligation to punish the perpetrator of the act. These are two distinct internationally wrongful acts, and both can be asserted as bases for the state's international responsibility. That is precisely the Gambia's case, that Myanmar is internationally responsible for genocide and simultaneously for breaches of the duty to punish genocide. The question that arises, therefore, is what is a state required to do in order to discharge the duty to punish? This question is answered in detail by the joint interveners, and the Gambia agrees with their position. The duty to punish must be interpreted as an obligation to investigate and prosecute people accused of genocide, and to punish persons found to be guilty of genocide. The duty imposes an investigatory obligation because this is a necessary step to imposing lawful punishments. As with all provisions of the Convention, the and impartial trials capable of imposing lawful punishments. As the Court explained in the Belgium v Senegal case, there in the context of the obligation to inquire about acts of torture, while the choice of means for conducting a criminal inquiry remains in the hands of the state concerned, the state is obligated to proceed effectively with adequate investigations. An equivalent requirement is imposed by the duty to punish in the Genocide Convention. Myanmar suggests in its counter-memorial that the duty to punish is an obligation of conduct and not of result. The intervention of the Maldives helpfully explains why Myanmar is wrong about this, and the Gambia fully agrees with their analysis. A respondent state cannot avoid responsibility for breach of the duty to punish in Article 3. It has breached its obligation to punish, irrespective of the reasons it may give for that failure. This may, however, be an arid debate in the circumstances of this case, because although Myanmar asserts that the duty to punish is an obligation of conduct and not result, It does not point to any conduct that it says it took to discharge this obligation. The essence of its case is simply that no genocide occurred and that therefore no duty to punish arises. Members of the Court, the Gambia agrees that the duty to punish only arises if genocide has been committed. But the duty to investigate, which forms an essential part of the duty to punish, arises as soon as there are reasonable grounds to believe that genocidal acts have been committed on a state's territory. The Gambia and the interveners which address this topic agree that this is the relevant trigger for engagement of the duty to punish in its investigatory modality. Myanmar posits an alternative, higher threshold, that the duty to punish only arises when the authorities have already obtained sufficient evidence to satisfy the evidential threshold under municipal law. There is no basis for importing that position into the Convention, and it would be wrong to do so for obvious reasons. The introduction of such a requirement would incentivise a respondent state to turn a blind eye to evidence or refuse to take reasonable steps to obtain it, so that it never held sufficient evidence to satisfy its municipal threshold and thus trigger the duty to punish. And it would incentivise a respondent state to set the municipal evidential threshold so high that it could not be met. And then to the evidence on failure to punish. My colleagues have taken you through it, particularly in Professor Darjon's speech yesterday, and I need not repeat what they have said. It is clear from the record that Myanmar would have been aware contemporaneously that there was a widespread belief that genocidal acts took place during the clearance operations. There were certainly reasonable grounds for believing that to be the case. And therefore, the duty to punish, at the very least by carrying out effective investigations in good faith, has been triggered. Myanmar is certainly aware of that now. But it has taken no meaningful action to investigate, much less prosecute or punish the perpetrators of genocidal acts against the Rohingya. In respect of that indicator, also supports the Gambia's case that Myanmar has violated its duty to punish. Isolated examples of prosecutions, none of which were for genocide, with international investigative standards. The few examples that exist, therefore, do not assist Myanmar in showing of Articles 1, 4 and 6 of the Convention. Nor have there been adequate prosecutions or other means of punishing the perpetrators. In totality, both in respect of genocide itself and in respect of the other genocidal acts to which I will turn later in my speech, there has been a clear violation of the duty to punish. There has also been a clear and ongoing violation of the duty to enact legislation under Article 5, which is itself a facet of the duties to prevent and punish. The UNFFM explained in its 2019 report that Myanmar's penal code has no provisions on the crime of genocide, an omission that is underscored by Myanmar's belated amendment to its penal code in 2021 to introduce an offence of genocide. The Gambia welcomes this development of Myanmar's municipal law, but the 2021 amendment still fails to give effect to the Convention, in particular because it does not apply to members of the Tatmadaw, who are subject to a separate military criminal code, which still fails to criminalise genocide, and who, therefore, despite being the predominant perpetrators of the genocide against the Rohingya, remain fully insulated from investigation or punishment for their genocidal acts. The new law also provides a carve-out for existing laws, meaning that measures introduced to restrict births in the Rohingya community under pre-existing laws that authorise such measures are insulated from prosecution under the Criminal Code, despite their genocidal character. The 2021 amendment therefore fails to meet the requirements of Article 5 of the Convention, and the Gambia thus invites the Court to determine that, alongside its commission of genocide and its associated failure to prevent genocide, Myanmar has also violated the duty to punish genocide, including the duty to punish other acts prohibited under Article 3, and by failing to put in place a domestic framework giving effect to the Convention. Mr. President, members of the Court, I will only address you on two of them: conspiracy to commit genocide in Article 3b of the Convention, and direct and public incitement in Article 3c. This is because the other violations which may be committed under Article 3 have been recognised by this Court to be either absorbed by or logically inconsistent with a finding that a respondent state has committed genocide. Since the core of the Gambia's application is that Myanmar committed genocide, and since, on the Gambia's case, the evidence presented to you this week convincingly establishes that it did, it is unnecessary for me to address you or invite that you make specific findings in respect of other acts which are encompassed by or would be inconsistent with that primary determination. The position is different for conspiracy and for direct and public incitement. While in certain factual situations, a court may consider that a finding of conspiracy or direct and public incitement is subsumed by a finding of the commission of genocide, these may, in other cases, be analytically distinct, and they may be worthy of distinct findings. The Gambia says that that is the case here. It is perfectly possible for a state to conspire to commit genocide and go on to commit genocide, as Myanmar did. So too is it possible for a state to incite others to commit genocide and also commit genocide itself. And the Gambia submits that that is precisely what happened here. These additional violations of the Convention, in the circumstances of this case, justify their own distinct findings by the Court. On conspiracy, I can be brief. A conspiracy to commit genocide arises when organs of the state enter into an agreement to commit genocide. A conspiracy may arise whether or not genocide is ultimately committed. And if genocide is committed, that does not displace the existence of the prior conspiracy to do so. On the evidence in this case, of course, the Gambia invites the court to conclude that a genocide did take place. But before that, Myanmar entered a conspiracy to commit it, because there was an agreement to act as it did between its highest leaders and military authorities. That agreement can be inferred from the highly coordinated nature of the clearance operations and from the dissemination of the Facebook posts and other materials indicating the existence of a plan which necessarily required agreement among its organisers. Agents of the Myanmar state were party to the agreement, including senior members of them should be investigated and prosecuted for genocide. Arrest warrants for some of them, including the Commander-in-Chief and the Deputy Commander-in-Chief of the Tatmadaw, have been issued by Argentina in the exercise of universal jurisdiction for the crime of genocide. But Myanmar has taken no steps of its own to investigate or punish the conspirators. Indeed, given their role as senior commanders of Myanmar's armed forces and government, their conspiracy was Myanmar's conspiracy. Alongside a finding that Myanmar committed genocide, the Gambia invites the court to hold that it also conspired to do so, and that it has failed in its duty to punish the individual conspirators. Finally, on direct and public incitement to genocide, a state will be responsible for this punishable act when a state organ speaks, publishes, or displays in public words that incite, which is to say, encourage or provoke the commission of genocidal acts. In its Radio Milcolleen judgment, the ICTR appeal chamber made clear that to determine whether speech constitutes incitement to genocide, it must be considered in its context when reviewing its potential impact. The court must consider how the words would be understood by their intended audience, so that it is open to a court to conclude that a speech which contains, and I quote, no explicit appeal to commit genocide, or which appeared ambiguous, still constituted direct incitement to commit genocide in a particular context. The ICTR Appeals Chamber in that judgment also endorsed and applied what was said on the correct approach to direct incitement in the Akayesu judgment, namely, that the direct element of incitement should be viewed in the light of its cultural and linguistic content. Indeed, a particular speech may be perceived as direct in one country and not so in another, depending on the audience. The Chamber further recalled that incitement may be direct and nonetheless implicit. A similar finding was made by the Supreme Court of Canada in the Mugasera case, that the direct element of incitement should be viewed in the light of its historical, cultural and linguistic context. And so, the history and context of discrimination and the long-standing denigration of the Rohingya that Ms. Pasipanojga addressed you on at the start of the week are thus directly relevant to the proper interpretation of the statements made by Myanmar officials and to the court's assessment of whether they constitute direct incitement to genocide. So too is the evidence of hate speech on which Mr. Suleiman addressed you. The Gambia accepts that there is a difference between hate speech and direct and public incitement to genocide, in that incitement always involves the additional requirement that the speech is understood by its intended audience as a call to violence or action against a divided group. Hate speech may also include calls to violence, and the definitions referred to by the UN fact-finding mission, including the 2017 Rabat Plan of Action, do address hate speech, including that which incites violence. The UN FFM also noted that Myanmar's hate speech against the Rohingya includes incitement to violence. And so while they are distinct, there may, as in this case, be considerable overlap between hate speech and incitement. The Milcolin Appeals Chamber judgment recognised this relationship, saying that in most cases, direct and public incitement to commit genocide can be preceded or accompanied by hate speech, as indeed it was in the case of the Rohingya. Hate speech also contributes to the relevant context, affecting how statements are likely to be received. The UN FFM recorded that it has no doubt that the prevalence of hate speech in Myanmar significantly contributed to a climate in which individuals and groups may become more receptive to incitement and calls for violence. That certainly seems to have been true for the ethnic Rakhine civilians who were ripe for incitement to genocide and who joined the Tatmadaws' genocidal efforts, for example, in Chukpyin and in Din, as you were told earlier in the week. The fact that the Commission of Genocide did in fact follow is a factor that, as the ICTR Appeals Chamber observed, will assist the court's interpretation of the words in question, casting light on the fact that, in their particular context, the speech was understood to be an incitement to genocide, and that this was indeed the intent of the author of the speech. On Monday, Mr. Suleiman took you to potent examples of Myanmar's hate speech, several of which also constitute incitement. I am thinking, for example, of Senior General Haing's September 2017 speech, making inflammatory allusions to the Rohingya and calling for all to be loyal to the state, right while the clearance operations were ongoing, and loyalty to the state would be understood as loyalty to and assistance of their genocidal campaign. There are further examples on the evidential record which also satisfy the legal test that in the relevant context they would be understood by their intended audience as a call to genocidal violence. For now, I draw your attention to just two examples drawn from the Facebook evidence which Mr. Suleiman addressed on Monday. First, a video posted on military pages on Facebook in August 2017, as the second wave of clearance operations were in their early stages. The video, reported on by the UNIIMM in its analysis of the material provided by Facebook, shows a soldier inciting ethnic Rakhine civilians to genocide. He told them, and I quote, "We will clear the villages where those animals live. We have guns, we have bullets, that's what we came with. With ammunition and the spirit to attack the animals, we have come here. If you can carry a sword, carry a sword. If you can carry a stick, then carry a stick. Carry whatever you can and bravely face these animals. In its context, this was a clear encouragement of genocidal violence against the Rohingya, and it falls within Article 3C.
I have no money.
Days later, in early September 2017, as the clearance operations continued, Tatmadaw Facebook pages posted a message calling on ethnic Rakhine to, and I quote, sharpen even the knives at home that you do not use. The post also alluded to historic violence allegedly committed by Muslims against Buddhists. In the context that existed in August 2017 in Myanmar, a post referring to Rohingyas and telling Rakhine to sharpen their knives would be well understood by its intended audience as incitement to genocidal violence against the Rohingya. The evidence shows that they were indeed understood as such. Mr. Suleiman took you to some of the responses posted under other similar Tatmadaw posts. Comments which said, "Don't leave any of those Muslim dogs alive and make them extinct." These and other examples on the record demonstrate convincingly that senior Tatmadaw officers openly exhorted soldiers and ethnic Rakhine civilians to commit genocide against the Rohingya. In the context of the long-standing vilification of the Rohingya by the Myanmar government, there could be no mistaking the genocidal appeal being made, and the evidence to which the court has been taken shows that the appeal was heeded. The Gambia thus invites the court to find that Myanmar, alongside its other breaches of the Genocide Convention, is also internationally responsible for direct and public incitement to genocide. Mr. President, members of the court, these therefore are the key substantive violations of the Convention which the Gambia pursues through this application. First, that Myanmar committed genocide. Second, that it violated the duty to prevent genocide. Third, that it violated the duty to punish, including the associated duties to try and to have in place domestic legislation giving effect to the Convention. Fourth, that it entered a conspiracy to commit genocide. And fifth, that it directly and publicly incited genocide. It is also part of the Gambia's case that Myanmar has breached the court's provisional measures order, a topic that Mr. Suleiman will address you on next. I thank you for your close attention this morning, and Mr. President, I ask that you now invite Mr. Suleiman to the podium to continue the Gambia's presentation.
I thank Ms. Jones for her statement. I now invite Mr. Al-Salan Suleiman to address the court. You have the floor, sir.
Mr. Suleiman, ayer.
Mr. President, members of the court, good morning. I will focus on Myanmar's violations of the court's unanimous order on provisional measures dated 23 January 2020. As the court recalled in that order, quote, orders on provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed, which in this case, of course, is Myanmar. I will discuss Myanmar's violations of the first three provisional measures. The Gambia does not argue that Myanmar has violated the court's fourth provisional measure, which relates to the filing of reports on the implementation of the provisional measures order. On that point, however, I do note that Myanmar's reports have tended to include much information that is irrelevant to the implementation of the order itself. To help assist the court, the Gambia will focus here only on information relevant to the violation of the measures themselves. The first provisional measure relates to the prevention of genocide. Myanmar must, quote, in relation to the members of the Rohingya group in its territory, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular, A, killing members of the group, B, causing serious bodily or mental harm to members of the group, C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D, imposing measures intended to prevent births within the group. Myanmar thus has been under an obligation since 23 January 2020 to take all measures within its powers to prevent the commission of all of the actus reus of genocide listed in Article 2 of the Convention, particularly sections A through D. Myanmar has failed to comply with this provisional measure. In relation to Article 2A and B, killings and causing serious bodily or mental harm, members of the Rohingya group have been killed or injured as a result of the military's activities in Rakhine State after the court's order. For example, according to the UN Special Rapporteur on the situation of human rights in Myanmar, quote, from 23 January 2020 to 22 January 2021, at least 33 Rohingya civilians were killed as a result of the conflict, with at least 39 others injured. In the year following the ICJ's provisional measures order, 19 Rohingya men, women, and children were killed as a result of targeted or indiscriminate attacks by the Myanmar military. 1 was killed in a targeted killing by police, 10 were killed as a result of landmines or unexploded ordnance, and 2 were killed in targeted killings by other unidentified armed groups. The 33 killed included 15 children and 3 women. In addition to the killings of Rohingya by the Myanmar military, scores more were injured as a result of incidents similar to those described above, and Rohingya are among the thousands of people who have been internally displaced by the conflict, end quote. According to reports of the UN Special Rapporteur in 2024 and 2025, Rohingya civilians have been killed and displaced by Myanmar military shelling and attacks in the context of its armed conflict with the Arakan army. Additionally, in the context of that same conflict with the Arakan army, the Myanmar military has forcibly conscripted Rohingya into military service, exposing them directly to killing in the conflict. According to a September 2025 report of the UN Office of the High Commissioner for Human Rights, quote, throughout the ground offensives in 2024, the military relied heavily on Rohingya forced recruits. Scores, possibly hundreds, of those men and boys recruited by the military remain unaccounted for, with many feared killed on the battlefield. Since the military announced the initiation of a conscription process in February 2024, over 5,000 Rohingya are reported to have been conscripted in the period up to June 2025, with this practice continuing into July 2025 in Sitwe IDP camps and villages, and Kyak Phu, prompting many to flee Rakhine. Information received indicated that only those who could pay military and camp leaders could avoid recruitment. Rohingya men who resisted recruitment risked being arrested, beaten, extorted, threatened, and detained. Conscripted Rohingya continued to be deployed at military bases and checkpoints, with the military extorting money from Rohingya families in Sittwe camps to support families of the recruits, exacerbating the already dire financial conditions. Credible reports indicate that many forcibly recruited Rohingya men from Sittwe camps in June and July were sent to fight the Arakan army in the ongoing battles in Kyokphu, and families have lost contact with them, with their whereabouts unknown. Hundreds of Rohingya youths have fled camps and villages to avoid conscription." End quote. The UN Special Rapporteur reported that these conscripts were forced to serve as, quote, "human shields." The reports of forced conscription were confirmed by the UN High Commissioner, Human Rights Watch, and independent media. The International Crisis Group reported that thousands of Rohingya are likely forcibly serving in the Myanmar military as, quote, "cannon fodder." Quote, "Desperate to hold on to power, the military regime has sought to foment intercommunal tensions, rallying some Rohingya to its side through a mix of coercion and inducements. Although authorities in Myanmar have long persecuted the Rohingya, including by denying citizenship to the vast majority of them and constraining their freedom of movement, the military has no qualms about using them as cannon fodder against the Arakan army. Facing the prospect of further defeats in Rakhine, the regime has conscripted Rohingya men from villages across the state's north, where the Rohingya still make up most of the population, and from internment camps near Sittwe, where some 130,000 continue to live after being forcibly displaced following the 2012 violence. Thousands of Rohingya are now likely serving in the Myanmar military as militia members, end quote. The UN Special Rapporteur and independent media investigations also reported that the Myanmar military forced Rohingya to protest against the Arakan army in Sittwe and elsewhere in Rakhine State, further inflaming communal tensions and placing Rohingya in danger of physical harm. The International Crisis Group corroborated that reporting and further reported that Myanmar has collaborated with ARSA to further inflame tensions. Quote, "In an effort to stoke intercommunal tensions, to destabilize its opponent, the regime has also coerced Rohingya into staging demonstrations against the Arakan army and collaborated with Rohingya armed groups, particularly the Arakan Rohingya Salvation Army, the outfit whose attacks provided the pretext for the 2017 crackdown, and which the military has long designated a terrorist organization," end quote. As intended, Myanmar's forced conscription practices have inflamed communal tensions between Rohingya and Rakhine communities. According to an October 2025 report of the UN Special Rapporteur, quote, "Junta forces have forcibly recruited thousands of Rohingya men and boys, many of whom have been deployed to the front lines of the fight against the Arakan army or used as human shields. Rohingya recruits have also been ordered to attack Rakhine civilian populations and destroy Rakhine property, escalating tensions between Rakhine and Rohingya populations," end quote. Because of the military's intentionally provocative actions, the Arakan army retaliated with attacks that have caused killings of Rohingya civilians and destruction of some of their villages in Buthadong Township, displacing thousands. Clearly, rather than taking all measures within its powers to prevent killings and serious bodily or mental harm to members of the Rohingya group, Myanmar has been doing the opposite, in violation of the court's provisional measures order. Pursuant to the court's order, Myanmar should have taken also all measures within its powers to prevent the deliberate infliction on the group of conditions of life calculated to bring about its physical destruction. That has not happened. The UN Special Rapporteur on the situation of human rights in Myanmar detailed the systematic nature of the discrimination that Rohingya continue to experience in Myanmar in his report of 1 July 2024. Quote, "The estimated 600,000 Rohingya who remain in Myanmar suffer under an apartheid regime enforced by the military. They face rigid segregation, severe restrictions on movement and access to education, healthcare, and employment, arbitrary arrest and detention, confinement to squalid IDP camps, and vulnerability to violence from armed actors and civilians. Since the coup, the already repressive environment for Rohingya in Myanmar has worsened. The SAC, which stands for State Administrative Council, has imposed new movement restrictions on Rohingya in Rakhine State and systematically blocked humanitarian aid deliveries and organizational access, cutting off Rohingya communities from life-saving aid. Rohingya also face a rapidly deteriorating security situation as they are increasingly caught in the crossfire of fighting between the SAC and Arakan Army. Since May 2024, thousands of Rohingya living in northern Rakhine State have been displaced from their homes with serious concerns about their safety, security, and access to food and shelter," end quote. In his report to the UN Human Rights Council on 13 June 2020, the UN Special Rapporteur on the situation of human rights in Myanmar explained how the cascading layers of discriminatory policies lead to preventable deaths for Rohingya. Quote, "The roughly 600,000 Rohingya in Rakhine
there are roughly 600,000 Rohingya in Rakhine.
Most villagers need to apply for permission to travel between localities in Rakhine State, a system that is enforced at checkpoints manned by security forces throughout the region. Since the coup, Rohingya have faced renewed arrest for undocumented travel. Travel restrictions and nighttime curfews can have life and death consequences, especially for those seeking treatment for acute medical conditions. An outbreak of diarrhea in Rohingya IDP camps that began in January 2022 has led to deaths that could have been prevented by timely medical treatment," end quote. Year after year, hundreds of Rohingya are arrested and imprisoned for, quote, "unauthorized travel within Myanmar." The dire conditions in Rakhine State have led thousands of Rohingya to attempt to flee these conditions by sea, resulting in tragic deaths every year. Hundreds of them. The Myanmar military has also restricted food supplies, and the resulting food scarcity situation has reached emergency levels and is contributing to health emergencies as well. According to the UN High Commissioner for Human Rights, quote, "Food scarcity across Rakhine has reached emergency levels, with deaths, disease, and malnutrition reported throughout the state. In northern Rakhine, the situation is acute, with most Rohingya surviving on a single meal a day. Internally displaced persons in those areas have been living in makeshift shelters or the homes of other Rohingya families, unable to access food, water, and sanitation. In central Rakhine, where as many as 70% of Rohingya IDPs in certain camps may be at risk of starvation, reports of suicides and attempted suicides due to hunger were also received. In these desperate humanitarian conditions, disease is rampant, with cases of acute watery diarrhea, scabies, hepatitis, malaria, and dengue fever reported." End quote. Rather than allow food aid in, the Myanmar military burned a World Food Program warehouse. According to the UN Special Rapporteur, quote, "In June 2024, junta soldiers looted and set fire to a World Food Program warehouse holding 1,175 metric tons of food aid, an amount that could have fed more than 60,000 people for a month." End quote. Access to adequate health care in northern Rakhine State continues to deteriorate, leading to preventable deaths. According to the UN High Commissioner for Human Rights, quote, "The availability and accessibility of healthcare services continue to decline, with numerous reports received of preventable deaths of children and displaced persons due to the absence of basic services and assistance." End quote. Due to the restrictive environment imposed by the military, Médecins Sans Frontières, the only healthcare provider for Rohingya in many parts of Rakhine State, suspended its operations there in June 2024. Rather than taking all measures within its powers to prevent the deliberate infliction on the Rohingya group of conditions of life calculated to bring about its physical destruction, Myanmar has made the situation worse. The second provisional measure, which relates to the non-commission of acts of genocide, requires that Myanmar, quote, "in relation to the members of the Rohingya group in its territory, ensure that its military, as well as any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence, do not commit acts of genocide or of conspiracy to commit genocide, of direct and public incitement to commit genocide, of attempt to commit genocide, or of complicity in genocide." End quote. Myanmar has failed to comply with this provisional measure as well. The evidence indicates that Myanmar's military continues to engage in various anti-Rohingya propaganda efforts that could amount to conspiracy or incitement to commit genocide. For example, on 8 October 2020, several months after the provisional measures order, Facebook announced the removal of 38 Facebook accounts, 15 pages, and 6 Instagram accounts that it determined were linked, quote, to members of the Myanmar military who had, quote, attempted to conceal was compelled to remove 3 pages, 18 accounts, and 1 group, all of which it found were linked to, quote, members of the Myanmar police force who had, quote, attempted to conceal their identities and coordination, end quote. The pages reached approximately 19,000 other Facebook users and included what Facebook characterized as anti-Rohingya content. These accounts that I'm just mentioning are separate from the accounts that were taken down by Facebook that I had discussed Monday afternoon. In July 2021, Facebook, quote, removed 79 Facebook accounts, 13 pages, 8 groups, and 19 Instagram accounts in Myanmar that targeted domestic audiences and were linked to individuals associated with the Myanmar military, end quote. Facebook found that this operation was linked to the Tatmadaw and its anti-Rohingya operations from 2018. Quote, "Our investigation revealed some links between this operation and the activity we removed in 2018. Although the people behind it attempted to conceal their identities and coordination, our investigation found links to individuals associated with the Myanmar military." End quote. On 24 February 2021, the Tatmadaw and military-controlled state and media entities were banned from Facebook and Instagram due in part to, quote, "ongoing violations by the military and military-linked accounts and pages since the February 1 coup, including efforts to reconstitute networks of coordinated inauthentic behavior that we previously removed, and content that violates our violence and incitement and coordinating harm policies." End quote. The Myanmar military also used other means of spreading anti-Rohingya propaganda. According to an investigative report by Frontier Myanmar, the military dropped pamphlets from the air in Sagaing in 2022 to, quote, "leverage offline distribution methods to spread hate speech, disinformation, and propaganda, much of it aimed at inflaming religious tensions," end quote. Another report by Myanmar Witness concluded, quote, "This rhetoric encourages discontent with Muslims and anti-military groups, as seen in the 2017 Rakhine clearance operations, which targeted the Rohingya, a Muslim minority group. The narratives and patterns of behavior identified in this investigation and by the UN's probe could not only support claims that the military are dropping these pamphlets, but also, worryingly, indicate the repeat of behaviors which occurred in the lead-up to the clearance operations in the Rakhine state," end quote. As documented in a December 2021 report by the United States Institute of Peace, the Tatmadaw spread hate propaganda seeking to link the anti-coup movement to Islam and Muslims. And its military spokesperson falsely claimed that the Organization of Islamic Cooperation, or OIC, is arming the opposition to the junta. Independent media reports in December 2021 and January 2022 confirm the Tatmadaw's dissemination of anti-Muslim hate pamphlets, falsely claiming that, quote, "the OIC is propagandizing against Buddhist people so they will turn on each other, insult the sacred religion of Buddhism, and kill monks," end quote. Some of these anti-Rohingya operations are migrating to other online platforms like Telegram, where they can spread with less visibility because of the private nature of the Telegram platform. Because the military continues to engage in various anti-Rohingya propaganda efforts that could amount to conspiracy or incitement to commit genocide, Myanmar has also violated the second provisional measure. The third provisional measure requires Myanmar to, quote, "take effective measures to prevent the destruction and ensure the preservation of any evidence related to allegations of acts within the scope of Article 2 of the Genocide Convention," close quote. By the building of border guard police facilities on top of those lands. The IIMM's report on this issue concluded that such actions, quote, "destroyed or permanently concealed much evidence of what occurred during the 2017 clearance operations," end quote. Mr. President, members of the court, for all of the reasons just discussed, Myanmar has violated the court's provisional measures order of 23 January 2020. It must be held accountable for these breaches in addition to its breaches of the Genocide Convention. Thank you for your kind attention. This concludes my presentation. I now ask, Mr. President, that you call Professor Pierre Dargent to the podium to address the issue of the remedies and legal consequences of Myanmar's breaches.
I thank Mr. Suleiman for his statement. Je donne maintenant la parole au professeur Pierre Dargent. Vous avez la parole, monsieur.
And I'll now give the floor to Professor Pierre Dargent. You have the floor, sir. Thank you, Mr. President. Mr. President, ladies and gentlemen of the court, let me mention now the legal consequences of the breaches of the convention which Myanmar is responsible for, and also the remedies requested by Gambia. Can I telegrammatically, first of all, mention the 5 items I shall be mentioning? 1, declarations of violation and of responsibility. 2, cessation. 3, reparation. 4, assurances and guarantees of non-repetition. And lastly, 5, remedies for breaches of the Provisional Measures Order. Mr. President, let me first mention, therefore, the declaration of violation and of responsibility requested by Gambia. Ladies and gentlemen of the court, Article 9 of the Convention, as you know, gives the court jurisdiction to rule on disputes, and I quote, relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3. It is a key function of the court under the Convention. The drafters of the Convention have given you the final say, the ultimate power to state in law and for the historical record whether a genocide has indeed been committed by a state party. You have the ultimate authority to say that genocide has been committed. The function, the responsibility is something that is yours. You are the keepers of the Convention. On the 22nd of July 2022, when you recognized the court's jurisdiction and admitted the application of the Gambia, you fully acknowledged this responsibility and took it on. We, all of us here today, realize the weight that you carry, the weight on your individual shoulders and the weight over the court as a whole, as the principal judicial organ of the United Nations. Mr. President, there is no doubt, and in fact Myanmar doesn't dispute that to rule on the responsibility of a state, it requires a determination of violation in the court's work, and the dispositives of the judgments of the court often and regularly include determinations of violation. And indeed, your judgment of the 22nd of July 2022 clearly established that the Gambia was entitled to ask the court to determine that Myanmar indeed has failed to comply with its obligations under the Convention, that is, to declare Myanmar responsible for the commission of a genocide. And you heard this from Ms. Jones, the Gambia therefore asked that the court declare that Myanmar breached Articles 1, 2, 8D and 3A of the Convention by committing a genocide against the Rohingya group during the clearance operations. As Ms. Jones explained, Myanmar on that occasion has necessarily and equally failed to comply with its obligation to prevent genocide under Article 1 of the Convention, and committed conspiracy to commit genocide in breach of Article 3B of the Convention. The Gambia also asks that the court declare Myanmar breached Article 3C of the Convention through direct and public incitement to commit said genocide. And lastly, that the court declare that Myanmar has breached and is still in breach of Articles 1, 4, 5 and 6 of the Convention, in that it is not punishing the perpetrators and the masterminds of the genocide for the acts listed at Article 3 of the Convention. Ladies and gentlemen of the court, these various determinations of failure to comply, which in your judgment will be declarations of breaches, these various determinations are crucial, indeed, to restore international legality. Determinations of breaches, as requested by the Gambia, contribute to the reparation of the injury suffered by the victims of the genocide, and I shall come back to that in a moment. The genocide is a composite fact under Article 15 of the International Law Commission's articles, and therefore the international responsibility of Myanmar, which the court will determine and established, will go back to the first of the actions of the series, that is, at least to the first few attacks in the first wave of the clearance operations. And as Ms. Jones and Mr. Suleiman asked and recalled, GAMBIA is also asking you to state that Myanmar has in fact not complied with your provisional order and that it is responsible for that. Ladies and gentlemen of the court, if you do indeed determine a failure on the part of Myanmar to comply with the obligations to punish genocide, then you must determine that there is a continuing breach of the obligations and that Myanmar must put an end to this situation of impunity that it has established and that is lasting until this day. Therefore, Gambia is calling on the court to rule and declare that Myanmar must put an end to these breaches and amend and complete its criminal law, and take immediately effective measures to try before an independent impartial court of law or before an international criminal tribunal the members of its armed forces, including the highest ranking ones, members of its police and other security forces, and any other individual under its jurisdiction who has committed acts prohibited under the Convention. And Myanmar must also make sure that these people are properly punished for such crimes if found guilty. Similarly, Myanmar must put an end to all public hate speech against the Rohingya under Article 3C and take all necessary measures so that such speeches are not repeated. It must also abolish and put an end to all the discriminatory measures aimed at destroying the Rohingya as a group, maybe more specifically the restrictions on marriages and on births, and it must also put an end to the confining and segregating Rohingyas in the camps and stop inflicting upon them conditions of life such as depriving them of medical care or food calculated to destroy them. Mr. President, let me move on to reparations. In this respect, the Gambia is asking the court to declare that as a breach of the conventions Myanmar is responsible for, it must comply with its obligation to make reparations in the interest of the victims of acts of genocide who are members of the Rohingya group. Myanmar opposes such a claim. It considers, for one, that the law of international responsibility is exclusively interstate law and therefore imposes no obligation to make reparations for the victims of acts of genocide who are not nationals of the applicant state. Moreover, Myanmar contends that Gambia has no standing to make such a claim. And lastly, Myanmar claims that Article 9 of the Convention limits your powers in this and your jurisdiction in this respect insofar as it would not allow the court to rule on the obligation of respondent state to make reparations unless these reparations are claimed by states whose nationals were and have been victims of acts of genocide. Mr. President, members of the court, not one of the objections raised by Myanmar holds, and after having reviewed them, I will look at the various forms that the obligation to make reparations incumbent on Myanmar should take. Let me first of all look at whether the state responsible for acts of genocide has an obligation to make reparation for injury caused for the benefit of the victims, regardless of their nationality. As the written submissions of the Gambia show, contemporary international law recognizes the right for victims of acts of genocide to get reparation for their injuries. Indeed, long gone is the time when the law of international responsibility only established relations between states, and this is a development that is indisputable. It stems from the international human rights law, and the convention is part of it. It was fully acknowledged by the General Assembly, and it has once and for all been enshrined in the jurisprudence of the court in the advisory opinion on the wall, which was then further confined by your advisory opinion of 2024. Myanmar still argues in its rejoinder, however, and I quote, that the state responsibility is as much interstate responsibility today as it was in 1948. The parties clearly disagree on this point of law, but the court will easily settle the issue in the light of its own jurisprudence and may indeed find in this respect some interest and find the Gambians' written submissions helpful, and I would refer you to them. Ladies and gentlemen of the court, can I, however, say that behind this theoretical objection raised by Myanmar, we find, in fact, more discrimination and more dehumanization of the victims, which indeed fueled the genocide. In some, Myanmar claims, in fact, that if they had killed foreign nationals, they would not argue against having to make reparations for the injury caused by such crimes should claims be made by the states of the nationality of the victims. But because these victims are, as Myanmar states, sections of its own population, sections, incidentally, which it refuses full citizenship to, for these reasons, Myanmar apparently has no obligation towards them in international law. And for Myanmar, Rohingya don't fully exist under Burmese law and can therefore not fully exist as subjects of international law, as holders of a basic right to reparation. In sum, no internal legal personality, no international legal personality. In this issue, the court will rule, and the Gambia trusts that you will reject this argument that aims at taking the law of international responsibility backwards. And indeed, over the last 80 years, contrary to what Myanmar claims, it has progressed. Myanmar also affirms that the Gambia has no standing to demand it perform its obligation to make reparation in the interest of the beneficiaries of the breached obligations, that is, in the interest of the Rohingya people. There again, the respondent resorts to retrograde legal arguments that disregard entirely the developments of international law as found in your own jurisprudence. As the court knows, this is an issue that was discussed in the International Law Commission when the discussion revolved around the identifications of states others than the injured states. And the wording used in Article 48, paragraph 2b of the Articles of Responsibility of States for Internationally Wrongful Acts was drafted while bearing in mind, and I quote, the case of a genocide involving only the nationals of the state responsibility, which is something that the Rohingya aren't even under Burmese law. When Article 48 was being adopted, the chairman of the drafting committee of the ILC highlighted that the principle according to which the non-injured state by the a state non-injured by the breach of a collective obligation may claim the responsible state performance of the obligation of reparation in the interest of the injured state or of the beneficiaries of the obligations breached is, as the chairman of the drafting committee was saying, a judicious and useful principle worth considering. 25 years on, the principle was indeed considered by the court when it identified the obligations of states in respect of climate change. As it looked at the right of all non-injured states to pursue a claim against a state in breach of a collective obligation, the court highlighted that such a state could not claim reparation for itself, but that it may ask, and I quote, for the performance of obligations of reparation in the interest of the injured state or of the beneficiaries of the obligations breached. The Gambia is not asking for reparation, for any reparation for itself, but that is exactly the claim it is making, and the claim is therefore perfectly consistent with your own jurisprudence, a jurisprudence which indeed confirms the existence of an obligation to make reparation on weighing on the state responsible for a breach of an obligation because of a wrongful act. And because the rejoinder of Myanmar came in more than 6 months before the July 2025 advisory opinion, it could not take this into account. But the Gambia still calls on the respondent to take due note of international law as expressed by the court. And now we know that the Gambia is entitled to request, in the interest of the victims of the obligations breached, the performance by Myanmar of its obligation to make reparation in favour of the persecuted Rohingya. The question is, does the court have jurisprudence? Does the court have jurisdiction under Article 9 to condemn Myanmar to make such reparations? And relying on partial extracts of the Travaux Préparatoires, Myanmar challenges this. Its claims, in fact, echo the erroneous claims put stating that there could be no international responsibility of a state towards individuals. It states that, seeing as in 1948 the only responsibility of a state for genocide under Article 9 was supposedly an interstate responsibility, therefore the court requires, in Myanmar's view, another jurisdictional basis to rule on the international responsibility of Myanmar towards the victims of its genocide. That is not the understanding the Gambia has of Article 9 of the Convention. Your judgment of 22 July 2022 stated the court's jurisdiction to entertain the application filed by the Republic of the Gambia, and that application concerns a dispute between the Gambia and Myanmar relating to the responsibility of Myanmar due to its failure to comply with its obligations under the Genocide Convention. The issue of reparations for injury caused by wrongful acts comes with the invocation of responsibility. The Gambia's application, which the court agreed to entertain, included a claim of reparation in the interest and for the Rohingya victims. This, of course, is an issue on merits, but as is the determination of responsibility itself. But the jurisdiction of the court to entertain the allegation of international responsibility made by the Gambia against Myanmar must, by necessary implication, include its own jurisdiction to entertain the obligation to make reparations. As such, obligations are automatically triggered when responsibility for international wrongful acts is established and such acts have caused injury. During its oral arguments in 2022, Myanmar argued that not admitting its own preliminary objections would raise questions concerning the entitlement of non-injured states to claim reparation on behalf of alleged victims who are not their own nationals. And I'm quoting here your own judgment. Even so, the court rejected Myanmar's preliminary objections and affirmed its jurisdiction to entertain the application and recognized Gambia's standing to invoke Myanmar's international responsibility. The res judicata for the 2022 judgment is not restricted, in our view, to the court's jurisdiction to entertain claims of a failure to comply and of cessation, which had in those days been expressly and positively adjudicated by the court.
In any event, members of the court, Article 9 of the Convention does not preclude in any way your jurisdiction over the Gambia's request in terms of when matters concerning reparation. First of all, the court has jurisdiction, and once again I'm citing Article 9, on disputes relating to the interpretation, application, and fulfillment of the Convention. It is the court's consistent jurisprudence, as it pointed out in the Legrand case, and I quote, that a dispute regarding the appropriate remedies for the violation of the instrument containing the basis of jurisdiction is a dispute that arises out of its interpretation or its application, and thus is within the court's jurisdiction, in such a way that, and once again I'm quoting, a separate basis for jurisdiction is not required by the court to consider the remedies a party has requested for the breach of the obligation. Myanmar, however, alleges otherwise. Not because Article 9 allegedly might contain an express limitation to this regard, but because it contains the precision according to which the jurisdiction of the court extends, and once again I'm quoting Article 9, to disputes relating to the responsibility of a state for genocide. According to Myanmar, this addition does not provide an inclusive specification to the chapeau of Article 9, but instead prevents the court from ruling on responsibility disputes bearing on reparations for individual victims of acts of genocide. This exclusion is allegedly justified by the fact that when the convention was negotiated in 1948, international responsibility was, according to Myanmar, an exclusively interstate matter, which is allegedly confirmed by the travaux préparatoires of the convention. Mr. President, members of the court, if you believe that international law of state responsibility has evolved since 1948, there is no reason to freeze in time the meaning of the words responsibility of a state, which appear in Article 9 of the Convention. Indeed, this is a term of art. Now, as you have recently recalled, in the Gabon Equatorial Guinea case, where parties have used a legal term of art in a treaty, they must be presumed, as a general rule, to have intended that term to have the meaning which it generally bears in international law. What's more, the term responsibility is assuredly a generic term, and as the court highlighted in the Costa Rica versus Nicaragua case, and I quote, where the parties have used generic terms in a treaty, the parties necessarily having been aware that the meaning of the terms was likely to evolve over time, and where the treaty has been entered into for a very long period or is of continuing duration, the parties must be presumed, as a general rule, to have intended those terms to have an evolving meaning. End quote. The fragmentary travaux préparatoires raised by Myanmar show in no way that the states who negotiated the convention had any intention to freeze in time the meaning of the word responsibility, Article 9. Whereas the convention quite obviously was agreed without any time limitation. Thus, there is no reason to reverse the presumption that the meaning of this generic term might have changed over time. Finally, as the Court underlined in Bosnia versus Serbia, concerning Article 9, the regime of international responsibility that the Court is called upon to implement to determine the legal consequences of the violations or the breaches of obligations of the Convention, this legal regime of international responsibility falls under the rules of general international law on responsibility of states for internationally wrongful acts, end quote. The Convention contains no specific international responsibility rules, and when it mentions state responsibility, Article 9 is simply referring to general international law rules without limiting them in any way. Mr. President, allow me to draw my conclusion on these three legal questions. The Court does have jurisdiction to rule on the Gambia's request that Myanmar be condemned to make reparations for the injuries suffered by the victims of acts of genocide for which Myanmar is responsible. I now come to the forms of reparation which, according to Gambia, are warranted here. In addition to the declarations of breaches of the Convention and of responsibility for genocide that the Gambia is calling upon you to make, the reparation of harm suffered by Rohingya victims should take on two forms, should mainly take on two forms: restitution and compensation. In international general law and international human rights law, restitution is the first form of reparation. As you know, it allows for the establishment of the statu quo ante. Here, the obligation to provide reparation under the form of restitution imposes upon Myanmar all the measures contained in paragraph 1329 of the Gambia's memorial. These measures also appear in paragraph 2bi of the submissions of the reply, and they appear on screen. I won't be reading these, but I would insist on the fact that each of these restitution measures focused, as you will see, on the victims and their immutable human dignity. Each of them is indispensable to attempt to provide reparation for the huge trauma that was individually and collectively suffered by surviving Rohingya. I won't read through these requests for restitution, but I would insist on two of them. Firstly, the first that appears on the screen, to allow the safe and dignified return to their place of residence of displaced members of the Rohingya group, whether they are displaced within Myanmar or abroad. This measure is absolutely essential, and I'm sure that you understand this fully. Secondly, return to the members of the Rohingya group their individual and collective property, including their land, houses, places of worship and communal life, fields, livestock and crops, or replace them in kind. This restitution measure is just as essential as the first, and it is an indispensable complement to it, because just as Mr. Alamin recalled, Myanmar bulldozed the attacked and burnt Rohingya villages and based many border police bases on their ruins and on the lands that allowed the group to survive. This phenomenon was specifically documented by the IIMM in the report that appears in tab number 7 of your file. This is a matter that I believe deserves the specific attention of the court, given that property restitutions or compensations were decided on by the Ethiopia-Eritrea Claims Commission. Of course, the loss, damages, and harm suffered by the Rohingya cannot know full reparation by these restitution measures. One should therefore find that Myanmar also owes reparation under the form of compensation. In accordance to the usual practice of the course, Gambia is requesting that in the absence of agreement between the parties on the amount of compensation owed by Myanmar to the Rohingya victims, the matter be ruled on at a later stage after the proceedings of the case. But Gambia would, of course, have no objection to the court deciding somewhat otherwise. For instance, the court could ask Myanmar to let it know, within a reasonable time frame, of the details of the restitution and compensation measures it intends to undertake, or that it has already undertaken, so that at a later stage in the proceedings, it would be possible to ensure that Myanmar's reparation obligation to the benefit of victims of acts of genocide that it will have been found guilty of are fully implemented. The Gambia believes that the institutional responsibility of the court to put an end to the dispute put before it requires more than a simple statement of the existence, or that Myanmar has an obligation to make full reparations of the harm suffered by the victims of its acts of genocide. Rather, the close monitoring of the respondent in the performance of this obligation is necessary, because reparation of the harm is owed to the victims of the genocide themselves. Mr. President, members of the court, the following remedy requested by Gambia has to do with the assurances and guarantees of not repetition that Myanmar must provide, given the very specific circumstances of the present case. It won't surprise you to hear that Myanmar disputes, again, the Gambia's standing to make such a request. However, this standing stems naturally from the erga omnes partes character of the obligations contained in the Convention, and the fact that, as a consequence of this character, as the court ruled on the 22nd of July 2022, any party to the Convention has a legal interest in ensuring that they are abided by, no matter the case. And that is why the Gambia can also ask paragraph 2A of the Articles on the Responsibility of States. The 2025 advisory opinion on the obligations of states regarding climate change confirmed the validity of the International Law Commission's conclusions on this matter. The court having ruled that a state not injured by the breach of a collective obligation can, and I quote, make a claim for cessation of the wrongful act and assurances and guarantees of non-repetition, as well as I recalled a moment ago, it can ask for the performance of the obligation of reparation in the interest of the injured state or the beneficiaries of the obligation breached. This point having been made, the circumstances of the present case, as they appear to you, require, according to the Gambia, assurances and guarantees of non-repetition of Myanmar. Indeed, members of the court, these circumstances amount to the extreme gravity of the wrongful acts committed and the lasting harmful effects of those acts, the fact that Myanmar is happy to fully deny those facts and its responsibility for them, Myanmar's persistent refusal to call the Rohingya by their name, Myanmar's continued distrust of the Human Rights Council by refusing any form of cooperation with its inquiry mechanisms, the breach of the provisional measures indicated by the court, and finally, the fact that in the midst of the proceedings, the military junta responsible for the clearance operations overthrew Myanmar's constitutional order. All these circumstances of unmatched gravity lead us to fear that Myanmar's genocidal projects remain in place. The court should therefore set aside the presumption of good faith that it has, in other circumstances, granted the respondent in the context of a border dispute. In the present case, to keep such a presumption would amount, according to the Gambia, to blindness or naivete that would be unusual for the court. The Gambia is not asking you to apply a presumption of bad faith regarding Myanmar. It is simply inviting you to see the facts for what they are, and based on those facts, to determine that assurances and guarantees of non-repetition are necessary. Mr. President, Myanmar's reaction to the measure requested by the Gambia should be enough to convince the court. The guarantee of non-repetition that the Gambia is asking to be ordered is quite basic. It amounts to Myanmar granting full citizenship to all members of the Rohingya group present in Myanmar or displaced following the genocidal clearance operations. In other words, the Gambia is asking you to make sure that Myanmar treats members of the Rohingya group as full citizens on equal footing with its other citizens. There's nothing extraordinary in this, I believe. In the first quarter of the 21st century, where we found ourselves. And actually this corresponds to the situation before the 1962 military coup, as was recalled on Monday. However, faced with this basic request, Myanmar applies the following in paragraph 1584 of its counter-memorial. The court cannot, by ordering guarantees of non-repetition, impose new citizens upon Myanmar and interfere with the demographic composition of the country. End quote. By reacting thus to Gambia's basic request, Myanmar is clearly showing that it intends to continue to treat the Rohingya as a foreign body that cannot be counted as a part of its demographic composition. Their segregation and persecution amount to identity-based state policy based on ethnic, racial, and religious discrimination, a policy that Myanmar fully accepts to have undertaken before the court, a policy that is being extended in the name of sovereignty and sacrosanct domestic matters. The ongoing persecution and destruction of the Rohingya are thus planned. What's more, by using the Notabum jurisprudence to support the rejection of any interference in the demographic composition of Myanmar, the respondent is only undermining its own case rather than providing the court with reasons to be reassured. Mr. President, members of the court, in addition to the request it is making, of course, the Gambia will welcome any other assurances and guarantees of non-repetition that the court would consider to be adapted to the present circumstances to prevent any reoccurrence of Myanmar's genocidal crimes against the Rohingya group. And in this regard, I believe that the principle of party disposition does not strictly apply in as far as the rights at issue are not just those of the applicant state, but those of all the parties to the convention. And the court, of course, is the guardian of that convention. Mr. President, the last remedies requested by the Gambia have to do with the breach of provisional measures ordered by the court that my colleague, Mr. Suleiman, has just addressed. There's no doubt that the new obligations brought about by the order of the 23rd of January 2020 is, of course, the international responsibility of Myanmar vis-à-vis the Gambia, and that under Article 41 of the statute, the court has jurisdiction to rule on the requests made by Gambia in this regard. Specifically, the Gambia has a right to have the court determine that Myanmar has breached the provisional measures ordered upon it. Such a determination would amount to adequate reparation under the form of satisfaction of the non-material injury of the Gambia. Myanmar does not argue against this point, even though it wrongly claims that it has fully complied with provisional measures. What's more, Myanmar must ensure the reparation of the harm caused to the Rohingya by its breach of provisional measures. Inasmuch as there has not already been reparation of this injury by the restitution and compensation measures owed by Myanmar as a consequence of its breach of the Convention, the respondent will have to separately ensure reparation, once again under the form of restitution and compensation. In this regard as well, and according to the breaches of provisional measures that the court will have found, a later stage of the proceedings will need to be devoted to the detailed implementation of the reparations that fall upon Myanmar. I once again thank the court for its kind attention, and may I ask you, Mr. President, to call Professor Philip Sands to the podium for a few conclusive remarks to this first round of the Gambia's pleadings. I thank Professor D'Argent for his declaration.
To the podium. You have the floor, sir.
Mr. President, members of the court, you have had a full week, so these concluding remarks will be brief. The facts are clear, they speak for themselves. I have just a very few number of points to make. First, you've now heard the totality of the submissions of the Gambia on matters of evidence and of law, and we can summarize those submissions rather simply. Whether you focus on the particular circumstances of what passed in the specific villages to which the Gambia has drawn your attention, or on the pattern of conduct across time and place, and whether you apply a standard of proof that requires evidence to be convincing, or a standard that requires the only reasonable inference, it is, we say, manifest. The acts of the Tatmadaw and of Myanmar, killing, causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about physical destruction, and imposing measures intended to prevent births. These acts were committed with intent to destroy in whole or in part the Rohingya group as such. Myanmar has not met its obligations under the 1948 Convention. Myanmar has committed genocide. So too has it conspired and incited genocide. So too has it failed to prevent and punish genocide. So too has it failed to comply with the Provisional Measures Order of this court. Now, my second point against that background is that you have not yet heard from the Gambia's witnesses or expert. That will be for next week, after Myanmar has concluded its first round. And no doubt, in the course of its submissions, Counsel for Myanmar will seek to convince you that the 1948 Convention is somehow not engaged because the facts you've heard this week are invented or exaggerated or depart from the truth, and that Myanmar, in fact, only ever acted by way of legitimate counter-terrorism, or because the standard for proving intent hasn't been met, or because the evidence before you cannot be relied upon because of the manner in which it was collected, its probative value, its veracity, its weight, its weaknesses, and so on and so on. To read the pleadings of Myanmar, as we have all done, is to be reminded of Victorian Britain, of Charles Dickens' warnings about the horrors of appearing before London's Chancery courts Chapter 5 of Bleak House. And I quote, "It's like being ground to bits in a slow mill. It's being roasted at a slow fire. It's being stung to death by single bees. It's being drowned by drops. It's going mad by grains." End of quote. Well, you'll have a chance to assess the evidence and the testimony for yourselves next week, when the Gambia's 3 eyewitnesses will appear in this great hall. They have, of course, travelled a very great distance to be with us. And they're here for a reason. For in truth, this is really their case. And it would not be right for them not to have an opportunity to tell you, the judges, exactly what happened to them, and for you to hear the voice of the Rohingya directly, and for them to be able to say that you have heard them directly. You have their written statements, and we trust that you have read them. You can read their first-hand accounts. 3 civilians, ordinary folk, people with aspirations like anyone else, targeted not because of anything they ever did, but simply because they happened to be members of the wrong group at the wrong time in the wrong place. Imagine as you listen to them what it means for that reason to lose your wife and 5 of your 6 children, simply because you happen to be a member of the wrong group in the wrong place at the wrong time. In their statements and in their words, you will read about the particular individualized acts of rape and abuse to which they were personally subjected. The killing of spouses, of parents, of children, all personally witnessed. The burning of homes, the destruction of villages, the sight of infants being disposed of by fire or water. The accounts are each and collectively, and by any reasonable standard, deeply harrowing. They're also fully credible, consistent with and supported by hundreds of other testimonies that you have. You'll hear the witnesses, and if you wish, you'll have an opportunity to put any questions you want to them. You're also going to hear from the Gambia's expert, Professor Newton. He's independent and he's authoritative. What does he say about the evidences and the testimonies that are before you, and the arguments you're going to hear in the coming days from Myanmar, that it was merely engaged in rather modest acts of local counter-terrorism, reasonable reactions to real threats? That's what you're going to hear in the coming days. Well, Professor Newton is blunt and he is clear, and he does not mince his words. No, he says, Myanmar's clearance operations demonstrated none of the characteristics or indicia associated with counterinsurgency. No, he says, the Tatmadaw operations were not random acts of spontaneous and uncoordinated violence conducted by renegade commanders of undisciplined outliers. Yes, he says, the clearance operations were planned and executed based on explicit command guidance and pursuant to orders. Yes, he says, the clearance operations were focused on annihilation of the civilian population. And yes, he says, they were accompanied by all the telltale signs of operational intent. These are his words. I can do no better than put on the screen more of his words. And I quote, "Any argument that the Tatmadaor's clearance operations against the Rohingya represented authentic or appropriate counterinsurgency is not credible. The clearance operations violated a wide variety of legal and moral constraints. There is no conceivable basis for such operations under modern military doctrine or developed state practice. The attacks were intentionally directed against the civilian population. They were juxtaposed against decades of oppression and human rights violations directed against the Rohingya on the basis of their ethnic and religious identity. The only plausible conclusion from the available evidence is that the clearance operations were conceived, coordinated and conducted with the intention of destroying the Rohingya population on the basis of their ethnic and religious identity." End of quote. That is an expert opinion. And as with the witnesses, you will hear him and you will have the opportunity to put any questions you want to him to test that evidence that he has given. Myanmar had an opportunity to put in counter-expertise. They have not done so. Mr. President, members of the Court, in this great hall of justice, as has already been mentioned, each of us bears the burden and responsibility of approaching with the very highest standards of independence, integrity and professionalism the questions of accountability for the heinous and terrible acts that you are called upon to address in this case. And you address these issues at a particular moment in time. There are some who now say that we live in a post-rules world, that there is no international law, that there is no need for any international law. All that these people say that really matters is the morality of one or two leaders. This is one of the great elephants in this great hall of justice, but it's not the only one. The fact that we are gathered here, and have been for a few days and will be for a few more days, is testament to the enduring reality of a world of rules and of law. Myanmar might like to wish that there was no such thing as a genocide convention, but there is, and it is emblematic restraints on their actions, that they can maim and rape and murder in the name of counter-terrorism or national interest, or that they can commit acts of genocide and other abuses with total impunity and with no accountability whatsoever. To accede to the arguments of Myanmar is to say, in effect, that it can act as it wishes, at will, not in a lawless world, but in a world with no laws. Mr. President, members of the Court, as we all know, the eyes of the Rohingya community are upon you and us, as are the eyes of the world. The Gambia has the very fullest confidence in this Court to do that which is required by this foundational international convention to protect the rights of the Rohingya community in Myanmar, the rights of the Gambia, and the rights of all parties to the convention. And we also have the fullest confidence that the Court will faithfully fulfill its missions as the principal guardian of this convention to ensure its continuing utility and effectiveness in a tough world. We trust, too, that you will not allow Myanmar to discredit and undermine, as it seeks to do, the meticulous, independent and authoritative work of the United Nations and the reports of its fact-finding mission and the independent investigative mission for Myanmar, work that has been done over many years and at a very great cost and at personal risk to many, many people. Mr. President, members of the Court, with these words, the Gambia concludes its first round of oral submissions. On behalf of the team, we thank you for your very kind attention throughout. And that concludes our submissions. Thank you.
I thank Professor Sands, whose statement brings to an end the first round of oral arguments of the Gambia. The court will meet tomorrow, Friday, the 16th of January 2026 at 10 a.m. to begin hearing the first round of oral argument of Myanmar. The sitting is closed.